In this video, I'll cover some important MCQs on Juvenile Justice Act 2015. So earlier there was an act called Act of 2000 of Juvenile Justice. Earlier Act of 2000 was not being properly equipped to address the child offenders and the protection of children there. So this act of the Juvenile Justice Act, it provides for both protection of children and its care. We will just cover some MCQs of the act, and I'll cover section 1 to 49. So the MCQs which are here are just up to section 1 to 49, and after that I'll bring another video covering the MCQs covering all the remaining sections there. So this is just MCQs belonging to section 1 to 49. First question is, aftercare as defined under section 2.5 of Juvenile Justice Act is applicable to. So 2.5 applies to what category? So option A says persons who have completed 18 years but not have completed 21. Second says completed 7 but not completed 16, and C says 12 but not who did not complete 18, and D says 16 but not 18. So as given under section 2.5, first option is correct, because persons who have completed the age of 18 years but not have completed 21 years. So these are the people who are eligible for or must be given persons requiring aftercare, and the act provides for aftercare to categories of those juveniles only, or even not juvenile, because it provides for up to 21 years. So 18 to 21 years are the persons who are entitled for aftercare. So first is the right answer. Second question is, petty offences as defined under 145 of JJAct means. So A says for which any offence for which maximum punishment under IPC or any other law is up to 6 months. Second says up to 3 years, and C says up to 1 year, and D 3 months. So if you have read the provision properly, clause 45 of subsection 2, it provides for up to 3 years, and either in IPC or any other law. Whatever offences for which maximum punishment under IPC or any other law is imprisonment up to 3 years, those are called petty offences under Juvenile Justice Act as provided in section 1 clause 45. Actually it is clause 2 of 45, not 1 of 45. So B is the correct answer. Next question is, public place shall have the same meaning as assigned to it in which act? So options, there are 4 options: CRPC, IPC, Immoral Trafficking Prevention Act of 1956, Prevention of Corruption Act. So clause 50 of section 2 provides for the same, and the correct answer of the same is option B, Immoral Traffic Prevention Act 1956. So these are such questions which are just covered by reading the bare acts properly. So B is the correct answer. Next question is, serious offences includes the offences for which punishment under IPC or any other law for the time being in force is. So it is the question is about definition of serious offences provided under clause 54 of section 2. So the options are, A says maximum imprisonment for a term more than 10 years but not minimum imprisonment or minimum imprisonment of less than 7 years is provided, and B says for maximum of 14 years but no minimum or minimum of less than 7 years. C provides for 7 years but either there is no minimum or less than 7, and D provides for a term more than life imprisonment, although that it is not possible that maximum imprisonment for a term more than life imprisonment is there. So it can not be the answer obviously. Earlier clause 54, which provides serious offences, it was a different definition before 2021. So the new definition, the earlier was substituted by a new definition of serious offences in 2021, and according to the new definition, earlier the provision was that where the punishment under IPC or any other law was imprisonment between 3 years to 7 years. This was the definition. Now after 2021 amendment, the definition has been changed, and according to the new definition, C is the correct answer. Where maximum imprisonment for a term more than 7 years, but no minimum imprisonment or minimum imprisonment of less than 7 years is provided. So then in those cases it is called serious offences. Earlier the definition was 3 to 7 years of imprisonment cases, but now it is where maximum is more than 7 but no minimum is provided, or minimum of less than 7 years is provided. Next question is surrendered child means. So surrendered child as defined under the act, options are A, who is found without any home or settled place of abode. B says who is relinquished by parents, guardian to the committee on account of physical, emotional and social factors. C says who does not have parents, no one is willing to take care of and protect, or is abandoned or surrendered. D says child deserted by his biological or adoptive parents or guardians who has been declared as abandoned by the committee after due inquiry. So these are the options, but according to the provision, B is the right answer. Next question is total number of general principles to be followed in administration of Act are. So certain general principles are provided under section 3 of the Act, and number of principles provided there are D, 16 principles are provided. So D is the correct answer. Next question is board must consist of. So as there is a composition of board provided under section 4 of the Act. So option A says any magistrate having 3 years of experience, and B says any judicial magistrate of first class having 3 years of experience, and C says any judicial magistrate. D says any social worker actively involved in health, education, welfare activities for 3 years. So if you read the provision properly, it cannot be any magistrate. First, because there is expressly provided judicial magistrate first class must be the judge who should be part of the board having 3 years of experience. So the first class magistrate and having 3 years of experience board, not the judicial magistrate. CJM cannot be, as expressly prohibited in the provision, and any social worker involved in health, education, welfare, these persons must have 7 years of experience, not 3 years. So the remaining options are incorrect. Only B is the right option. Next question is at least one member of the board must be. So A says women, B child specialist, C says educationist, and D says child welfare activist. So the right option is A, woman. At least one member of the board must be woman. Next question is principal magistrate may be terminated after holding an inquiry by state government if. So A says guilty of misuse of power vested under this act. B says fails to attend the proceedings of the board consecutively for 3 months but without any valid reason. C says fails to attend 3/4 of the sittings in a year, and D says principal magistrate cannot be terminated under the act. So if you read the provision properly, this will imply that the principal magistrate can not be terminated under the act. So D is the right option. Next question is which amongst these is correct? A says only one board of juvenile justice can be there for one district. B says board forming a bench shall have power as metropolitan magistrate or judicial magistrate of first class as under CRPC. C says only principal magistrate of board forming a bench shall have power of metropolitan magistrate or judicial magistrate of first class as under CRPC. And D says A and both are the correct. So if you read the provisions again properly, then you will find out that correct answer is B, that board forming a bench shall have as power as metropolitan magistrate or judicial magistrate first class as under CRPC. It's not just for principal magistrates to have such powers but exercise such powers, but the whole of the board shall have such power as of metropolitan magistrate or JMFC provided in CRPC. So B is the correct option. Next question is any person who has completed 18 years of age and is apprehended for committing an offence when he was below the age of 18 years. Then options are A, if not released on bail by the board shall be placed in a place of safety during the process of inquiry. B says if released on bail by the board shall be placed in a place of safety during the process of inquiry. C says whether release on bail or not shall be placed in a place of safety during the process of inquiry, and D says shall be released on bail by board. So the correct option is option A, if not released on bail by the board shall be placed in a place of safety during the process of inquiry. So A is the correct option. Next question is which amongst these is correct with respect to the procedure of board. A says a child in conflict with the law must be produced before the principal magistrate of the board when the board is not sitting. B says a board may act notwithstanding the absence of principal magistrate of board. C says any difference of opinion amongst the members opinion of principal magistrate shall prevail, and D says all of these. So which amongst these is correct is the question. So B is the correct option. A board may act notwithstanding the absence of principal magistrate of board. Here it is the wrong option, because it is the majority view must prevail, not of the principal magistrate, and here the correct option would be that it can be produced before any member of the board. So that's why B is the correct option. Next question is child alleged to have committed a bailable or non-bailable offence upon his arrest. Options are A, be released on bail whatsoever may be the circumstances. B says shall not be released if release is likely to bring that person into association of the victim of the offence. C says when the child in conflict not released on bail by OIC be kept only in the custody of their parents. Then D says child can be denied bail even in bailable offences. So correct answer is option D, child can be denied bail even in bailable offences. The reason is that option A is incorrect, because it says the child must be released on bail whatsoever may be the circumstances, but that's not the case. Where there are the circumstances where the child can come into association with the other some criminals or can be exposed to some danger. In that case, the child shall be kept under observation home or place of safety. So B is also incorrect, not person into association with the victim of the offence, but it is that when the child can come into association with the known criminals, or he can be exposed to some danger and all. So even the C is incorrect, because he can be kept only under place of safety or observation home. So that's why D is the correct option, because even if the offence is bailable, if there are the circumstances where the child has some threat of involving with other criminals, or he has some danger, then even in bailable cases he can be denied bail. Instead he can be sent to observation homes or place of safety. So that's why D is the correct option. Next question is a social investigation report shall be submitted within. So option A says 30 days from the date of first production before the board. B says 15 days from the date of commission of offence. C says 15 days from the date of cognizance of offence is taken by the board, and D says 15 days from the date of first production before the board, and that's the right answer. 15 days from the date of first production before the board. So D is the correct option. Next question is, in case a person alleged to have committed an offence claims before a court that the person is a child or was a child on the date of commission of the offence, then what is the procedure? So option A says the court shall make an inquiry and take such evidence. D says the court can decide the question of age if raised before final disposal of the case, and C says the court may take affidavit of the proof of age if no other evidence is available, and D says all of these. So right option is option A, the court shall make an inquiry and take such evidence. So option A is the correct option. Next question is maximum time within which the board has to complete the inquiry regarding child in conflict with law. So what is the time period within which board has to complete the inquiry regarding child in conflict with law? So option A says 4 months from the date of first production before the board. B says 6 months from the date of commission of offence. C says 4 months from the date of cognizance of the offence is taken, and D says 6 months from the date of first production before the board. Right answer is 4 months. 4 months from the date of first production before the board, not from the commission of the offence. So 4 months time period from the date of first production of the child before the board. So A is the right option. Next question is a preliminary assessment in case of heinous offences under section 15 shall be disposed of by the board within a period of. So again the time period is asked. So options are 3 months from the date of first production before the board. B says 2 months from the date of commission of offence. C says 3 months from the date of cognizance of offence is taken by the board, and D says 6 months from the date of first production before the board. The right option is 3 months from the date of first production before the board. So 3 months is the correct answer. Next question is, board shall follow procedure for trial in summons cases under CRPC, warrant cases as summary cases, or plea bargaining under CRPC. So as per the provision, right option is option A, summons cases as provided under CRPC. So trial as summons cases shall be conducted by the board. So A is the right option. Next question is, where the board passed an order that there is a need for trial of the child as an adult, then the board may order transfer of trial of the case to which authority? So the options are to CJM or MM of the district. B says judicial magistrate having jurisdiction. C says principal sessions judge of the session. D says children court having jurisdiction. So you know, as per the provision, when some juvenile is to be tried as an adult, then children court has this jurisdiction to try it. So the children's court having jurisdiction would be the correct option. So D is the option. Next question is, the children's court shall ensure that the child who is found to be in conflict with law is sent to a place of safety till. So A says he attains the age of 18 years and thereafter the person shall be transferred to reformatory home. And B says until 21 years and then he shall be sent to place of safety. C says until 21 but he shall be sent to thereafter to jail. And D says till he attains the age of 18 years and thereafter he shall be transferred to a jail. So which is the correct option? Option C is the right answer. Till he attains the age of 21 and thereafter he shall be transferred to a jail. 21 and then jail. So C is the right answer. Next question is, an offence prescribing a maximum sentence of more than 7 years but not providing any minimum sentence, or providing a minimum sentence of less than 7 years. Such offence falls under what category provided there in the Act? So these such offences are called serious offences as provided under clause 54 of section 2. So B is the right answer. This classification was provided under this interpretation of such category of offences when the maximum sentence of more than 7 years is provided but not providing any minimum sentence, or providing a minimum sentence of 7 years. So these cases are called serious offences, and it was held in Shilpa Mittal versus NCT of Delhi, Civil Appeal 34 of 2020, Shilpa Mittal versus State of NCT of Delhi. So this was the case where it was held by the court. Next question is, which amongst these is correct? A says a child can be summoned to produce document under 91 of CRPC. B says child in conflict with law if convicted under 302 of IPC can be sentenced for as provided under 302 of IPC. C says child in conflict with law may be sent to prison by a board for maximum 3 years, and D says none of these. So correct answer is none of these. None of these things can be done against a child as juvenile provided under Juvenile Justice Act. So D is the right answer. Next question is, qualification to be appointed as a member of welfare committee includes. So what are the qualifications to be a member of child welfare committee? So A says degree in human psychology, and B says person actively involved in welfare activities pertaining to human life for 7 years. C says practicing professional in human health, and D says all of these. Right answer is C, a person practicing professional in human health. And there are other categories of persons having some qualifications there which can be member of child welfare committee. Here amongst these options only C is the correct option. So C is the answer. I have separately provided this paragraph for understanding the previous question. So you can read this paragraph. Next question is, which amongst these is correct? So A says a member of the child welfare committee may be removed from the membership if he fails to attend half of the sittings in the year. B says no person shall be appointed for a period of more than 3 years as member of the committee. C says no one can be eligible for selection as a member of the committee having past record of violation of animal rights. D says none of these. B is the right option. No person shall be appointed for a period of more than 3 years as member of the committee. Rest are incorrect. Please read the provision properly. B is the right option. Next question is, the committee shall have authority to dispose of cases of children in need of care and protection with respect to. So what is the power of committee? It is the question. In cases of children in need of care and protection. So as per the provision, all of these is the correct option: care and treatment, protection, development and rehabilitation. All of these comes under the domain of committee to decide with regard to children in need of care and protection, and D is the right option. Next question is, which amongst these is responsibility and function of child welfare committee? A says directing placement of a child in a foster care. B says direction to conduct social investigation and submit a report before the committee. C says conducting inquiry for declaring fit persons for care of children in need of care and protection, and D says all of these. So provision says all of these is the responsibility and function of the committee there. So D is the right option. Next question is, any child in need of care and protection may be produced before the committee by child himself, can be there, and public spirited citizen, probation officer, any of these. So any of these is the answer. All of these are given under the provision. So D is the right option. Next question is, punishment for non-reporting of child who got separated from parents is. Option A says imprisonment up to 1 year or fine of 10,000. B says imprisonment up to 6 but fine up to 5, and imprisonment up to 6 up to 10,000 of fine, and C and D says none of these. C is the right option as per the provision. Imprisonment up to 6 months and fine of 10,000. So C is the right option. Next question is, a parent or guardian wishes to surrender a child shall produce a child before. A says Juvenile Justice Board, B says Child Welfare Committee, D says District Child Protection Unit, and any of these. So any of these is not the answer. The correct answer is Child Welfare Committee. Child Welfare Committee is the authority before which the child must be produced for the surrender. So B is the right option. Next question is, categories of children who may be declared as child legally free for adoption. So as you see the provision, any of these is the correct answer. Or for abandoned or child of mentally retarded parents, all of these are the categories of children which can be declared as child legally free for adoption. So D is the right option. Next question is, as per section 40 of the Act, restoration and protection of child means restoration to. So according to the provision, section 40, any of these is the correct option. Parents, adoptive parents, fit person, foster parents. Restoration means to restoration to any of these. So D is the right option. Next question is, object of open shelter is. So what is the object of open shelter? Residential support to children in need. B says protection from abuse of children. C says keeping away from a life on the streets, and D says all of these. So all of these is the right option. All of these is the answer, as all of these options are there under the provision. Next question is, criteria for sponsorship shall include. So option A says where parents are victims of life-threatening disease. B says where mother is a widow or divorced. C says parents are incapacitated due to incident and unable to take care of children, and D says all of these. All of these again is the right option. Any of these can be the criteria for the sponsorship. So D is the right answer. Next question is, facility of observation home is created for the benefit of. A says for any child alleged to be in conflict with law. B says for child in need of care. C says for both child in need of care and in conflict with law, and D says none of these. So right answer is A, for any child alleged to be in conflict with law. So this was the observation home facility was made just for child who are alleged to be in conflict with law. So A is the right answer. Next question is, facility of a special home is created for the benefit of. A says for child alleged to be in conflict with law during pendency of inquiry. B says for child in need of care. C says both for child in need care of in conflict with law. And D says for child found to be in conflict with law. So child who are found to be in conflict with law is the right option. Special homes are made for the children who are found to be in conflict with law, not alleged to be in conflict with law. So D is the right answer. Next question is, which amongst these is correct with respect to place of safety? So A says a facility to a person above the age of 18 years in respect to commission of heinous offence. B says a facility for children, child in conflict with law who is between the age of 16 to 18 years and is accused of or convicted for committing a heinous offence. C says stay of such children or persons during the process of inquiry and children or persons convicted of committing an offence. And D says any of these. So right option is D, any of these. Any of these can be the object. Any of these can be the child or persons for which the place of safety can be used. So D is the right answer, any of these. So that's all in this video. If you like the video, please subscribe the channel, and I'll bring more MCQs on this act for remaining sections there. It was just section 1 to 49 in this video. Thank you so much for watching.